Welcome, everyone. Hey, this is Gayle Weiswasser. I thank everyone for joining us here on this March evening to hear our classmate Jeff Shesol talk about the Supreme Court. Before we get into that, just a couple of things. This is the second in a series of class connections that we're doing. Your class officers are organizing these to kind of keep our classmates in touch. And these class connection sessions are featuring people from our class who are doing interesting things. We had one last year where we talked about actually also the Supreme Court and affirmative action. And I'm going to just let you know that we're going to be doing another one in May, which is going to focus on alumni from our class who are doing interesting things in the arts. So people who are acting or casting agents or musicians or artists. So keep an eye on your email for that, and we'll be planning that for later on this spring. A little bit of housekeeping before we get started. We're going to be talking to Jeff. I'll be talking to Jeff for about half an hour, asking him some questions. And then once we finish, we'll turn the floor over to you guys. And if you have questions for Jeff, please feel free to ask them. You can either raise your hand at the time that we open it up. You can either raise your hand on Zoom and we'll just share the screen and have you ask the question on camera. Or if you don't feel comfortable being on camera, you can just put it in the chat. So before we get started, first of all, a little note about the music that we heard before. I chose that song, first of all, because REM always reminds me of Brown. And secondly, because it does feel like we're in a little bit of an apocalypse. So yes, it may very well be the end of the world as we know it. So thanks for those of you who commented on that in the chat. Okay, I'd like to take this chance to talk about Jeff. Jeff Shesol is the co-founder of West Wing Writers, which is a speech writing agency here in DC. Jeff and I are both in DC. He is the author of 3 books about American history. The most recent one is Mercury Rising, John Glenn, John Kennedy, and the New Battleground of the Cold War. Before that, he wrote a book called Supreme Power, Franklin Roosevelt versus the Supreme Court. And before that, he wrote a book called Mutual Contempt, Lyndon Johnson, Robert Kennedy, and the Feud That Defined a Decade, which, if I'm not mistaken, Jeff, I believe was an outgrowth of your senior thesis. Is that correct?
It was.
Okay.
It was.
So he spent a couple years working on that at Brown and then turned it into a book. In 1997, then President Bill Clinton read that book and invited Jeff to become one of his speechwriters. So Jeff spent 3 years at the White House writing speeches for the president, became deputy chief speechwriter and a member of the senior staff. Jeff was also a Rhodes Scholar. He got a master's in history from Oxford after we graduated from Brown. But I think probably Jeff is most well known in our class for being the creator of Thatch, my favorite cartoon strip ever. It appeared in the BDH for many years and then was nationally syndicated as well from 1994 to 1998. One of my favorite memories of Jeff, who's one of my good friends from Brown, was that he would sit in class and take notes in one of the many history classes we took together and doodle all up and down the sides of his pages. And occasionally he would doodle on my pages in my notebooks, and those were always my most treasured notes from Brown. So I'd like to welcome Jeff to our talk tonight, and thank you very much for joining us.
Thank you, Gail. And thanks for just retroactively. Thank you for letting me doodle in your notebook.
It's a pleasure.
And thanks for that introduction. It's really, I've been looking forward to having this conversation with you. Most of our conversations happen in the halls of the high school that our kids have shared. So I'm glad to shift forums a little bit. And it's amazing to see however small the faces are here in these little
Okay,
squares
so I
on
want
the
your advice
screen.
on something.
What's that? It's amazing just to see all of these familiar faces and these names, and thank you all for coming out to hear us talk about the end of the world, as it turns out.
Exactly. You know, it took Jeff and I quite a while to get this schedule just because we were bandying dates back and forth for a long time, but it turns out that we actually picked a really good date to have this. So without any of our own doing, March 6th turned out to be the perfect night to have this. So let's jump into this right now. we are definitely living in some pretty extraordinary times when it comes to Supreme Court. The court is perhaps more divided and more partisan than it's ever been, and it is clearly playing a very active political role, most notably in the upcoming presidential election. So let's talk about that a little bit. Have you ever remembered a time, other than potentially Bush versus Gore in 2000, when the Supreme Court has played such a direct role in the political landscape?
Well, I should preface this actually with a disclaimer, which as my wife Rebecca Epstein, 92, who is here on the call, will point out. My wife, who is an actual lawyer, meaning went to law school, has a JD, passed the bar. I am not, in fact, an actual lawyer in any of those ways. That said, I did take advisors politics of the legal system, so pretty much the same thing. And I do have a view on some of these things, developed not just during advisors class, but during the work that I did on my second book. You mentioned that I had done a couple of these. So my second book was on the court packing fight of Franklin Roosevelt in the 1930s. So my own memories don't go quite as far back as that, but I think there's no question this is a historically partisan period of time in the country and on the court. Looking at the court specifically, which we're here to do, we're a very long way from the 1950s, the 1960s, when you could conceivably have a justice appointed by, say, a Republican president like Roosevelt. You could have a justice like Earl Warren or Justice Brennan appointed again by a Republican who emerge as leading liberals on the court. Or even the 70s, when Justice Stevens, appointed by Richard Nixon, of all people, emerged as a great liberal champion over the succeeding decades. What we've seen since then is a much greater adherence of any given justice to the party line. I should also say, though, that this is not really an occasion, although it so often is when you read about it, of both sidesism. Yes, it is absolutely true that the three justices that were appointed by Democratic presidents are progressive justices or liberal justices. But I think what we've seen on the court is what we've seen in the country and in the Republican Party writ large, which is that you see what the political scientists are calling asymmetrical polarization. I'm sure you've all read about this. You've certainly all witnessed it, which is that the parties are not migrating toward the polls at an equal rate. And Democrats are actually and the liberal justices, you could say the same thing of them, are actually pretty close to the center, while the right has moved farther and farther to the right. You've seen that on the court, which is why we not only have the most partisan court in a very long time, but the most conservative court since the 1930s. And, in fairness to the justices in the 1930s, those guys grew up in the 19th century. I mean, Chief Justice Charles Evans Hughes, class of 1881, we should point out, when he was a student at Brown, he had two closets in his room, which I think was in Slater, but I'm not entirely sure. He had two closets, and one of them was for the coal that he would shovel into his furnace. So these guys came of age in another century, in an entirely different era, and we're grappling with the problems of the 1930s. I don't know that you could say the same thing necessarily about the justices who are moving the country to the court on the right now. So why is the court so much more partisan? I mean, you could just as well ask why is the country so much more partisan? There are these sort of broader trends, and the justices are not immune to it in many ways. They're both the product of it and they're the agent of it in many important ways. They're also, as we know, they're the products of this sort of vast machinery of the conservative judicial industrial complex that just sort of churns people out, to sort of moves them through the law schools and through the Federalist Society. And by the time they find themselves on the bench, and then, as appellate judges generally, and then on the Supreme Court, you have a pretty clear sense, and the presidents who appoint them have a pretty clear sense of exactly which way they're going to rule on all the most important issues to that side. So the mantra that we remember of the Republican Party in the 1990s, no more suitors, never again were they going to allow a David Souter to be appointed who might stray from conservative dogma, has now become no more O'Connors, no more Kennedys, and we're not likely to see any more Souters, O'Connors, or Kennedys. And so, Gail, this sort of brings me elliptically back to the question you raised. Has the court ever played so direct a role in the political landscape? Not in our lifetimes. I mean, it's always playing an indirect, important role in shaping the political landscape, whether you're talking about cases from previous decades, one person, one vote, or Buckley Vallejo, which is focused, on which equated political spending with free speech, or more recently, Citizens United or Shelby County, which gutted the Voting Rights Act. So the court is always sort of having an impact on the political system and confining or directing the choices that we're able to make within those boundaries. But this is pretty direct because we're really all concentrated here in these cases, which we might talk about, I imagine, on one major party candidate who is effectively a ward of the criminal justice system by this point. So the court probably would have liked to stay out of all that sordid business, but Trump hasn't really given them a choice.
Got it. Thank you. So let's talk about what can be done to kind of how people have proposed kind of curbing some of that power. So for people who feel like the court has too much power, there are some proposals that are out there that would fundamentally alter the makeup of the court, whether we're talking about adding justices or imposing term limits. We've had this Supreme Court now for hundreds of years. What do you think about these proposals? Are they desirable? And do you think they ever have any chance of being passed?
Well, sort of tackle both halves of that question. What we're generally talking about when we're talking about court reforms, we're talking about court packing. And so when I wrote that book that I mentioned, and I wrote that book back, it was published in 2010. It never really occurred to me that we were going to be discussing court packing in the news, that it was ever going to be proposed by any reasonable members of either political party. I wrote that book to answer a historical question, which is just to figure out, how does this happen? I mean, how does such a seemingly crazy idea possess somebody as politically astute as Franklin Roosevelt? How does a president make such an enormous miscalculation as to try to pack the court? But again, here we are. And the question why we're here and why we're talking again about packing the court, I mean, it strikes me as pretty straightforward. I mean, this is a maddeningly frustrating, terrifying, aggravating, infuriating situation. And when that set of feelings builds and it has no effective outlet, and if you want to smash something, court packing, it has a lot of appeal. It's a blunt instrument. The idea that with a vote of the Congress, a simple majority of Congress, that you could change the number of justices overnight, and you can. It's perfectly constitutional. There's no debate about it. It's extremely tempting. And it's tempting from the perspective not just of practical politics or jurisprudence, but it's appealing from the perspective of poetic justice. The engineering of this court that was done, that was managed so brilliantly by Mitch McConnell during the Trump years, that gave them the majority that they now enjoy. The idea that sort of in one fell swoop that you could reverse that and you could just flip the numbers of the court is extremely appealing. I get that. I mean, it's appealing to me because what else are we left with? Just sort of waiting for, at one point in the middle of the crisis between FDR and the Supreme Court, one of the Democratic senators said to Roosevelt, "Father Time is on your side." And that was the oldest, to that point, that was the oldest Supreme Court in American history. But Roosevelt didn't feel that the time was on his side. He felt that the country was in a crisis and the crisis was only going to be magnified if he couldn't begin to get these reforms through the Supreme Court, and if the Supreme Court was going to be a brake on progress. So the idea of just sort of waiting around for an opening to happen during the right time frame when there's a Democrat in the White House, it's not very appealing. And so I get the pull toward court packing. It has no future except as a rallying cry. I mean, the idea that even a good number of Democratic senators are not interested in this, and they understand that it would set in motion a cycle of retribution where Republican candidates would promise that on day one of their administration they were going to quote they're going to unpack the court, by increasing the number of justices from what, from 13 to 17. I mean, there's no potentially no end to that sort of tit for tat. And before you know it, you've got a Supreme Court of 21 or 27 people. But it's not going to happen in the first place. And so what conceivably could happen? Well, right now, frankly, nothing. There's no energy for court reform. But interestingly, in the country, there's a great openness to a solution that is sort of right there, even if it's a difficult one to get to, and that is term limits. There are a lot of variants on this theme, a lot of variations on this theme. But the idea of, for example, 18-year terms, regular staggered appointments, so that there's an appointment to the Supreme Court every 2 years, and every president who serves 4 years will have 2 appointments over the course of their administration. More than 2/3 of Americans support that idea right now. And even more than half of Republicans support that idea. As one of the advocates of it says, it's the closest thing to a consensus that we have in this country. At the same time, you don't hear a lot of people out there sort of protesting on behalf of term limits for the Supreme Court. There's support for it when people are asked a question in a poll, but there's not a lot of energy for it. There's no impetus for it, and there's certainly no great champions for it in the Congress where it really needs to begin in earnest. And so, I, among other people, have spent a lot of energy, fruitless energy, in the last couple of years, criticizing President Biden for failing to make the case for this reform. And it's going to take a while to build a consensus, a genuine consensus in this country, to move toward a system where an appointment of a Justice Thomas doesn't have to be a life sentence for all of us. But it's got to begin at some point, and we're not there.
All right, so speaking of polls, 58% of Americans are unhappy with the job that the Supreme Court is doing. They disapprove of them. Can you think of any other time in history when the Supreme Court has been so unpopular?
Maybe last year after Dobbs, it was 1 point worse, I think I read. It
Okay,
depends on which poll you're looking at. This is either the low point or, just barely above. A
right.
hair's breadth above the low point. Gallup has only been polling approval ratings of the Supreme Court, as far as I've been able to tell, since about 2000. They have been polling trust in the judiciary since about 72. This is the low point. And it reflects, I think, a bunch of things. I mean, it reflects a kind of general loss of faith in institutions. We have less faith in everything. The Supreme Court used to sort of be the bright spot, that no matter what we thought of anybody else in any other kind of public office, we thought the justices were okay. That's not true any longer. And frankly, it doesn't help when you have as Elena Kagan has said repeatedly, when you have a court that stops acting like a court, when it becomes very clear that this is just politics by another means. And it also doesn't help when you have a court that is obviously so intent on transforming as quickly as possible and as completely as possible law and policy in American life. It's not the first time the court's been a lightning rod. We talked about the 1930s. Back in the 1920s, the court erased more laws from the books in a 9-year period between 21 and 1930 than it had in its preceding 100 years. You had a presidential candidate, admittedly a third-party presidential candidate, Robert La Follette, who wanted, in his words, to, quote, put the axe to the root of the Supreme Court and take away its ability to be the last word on the law, and to give that to Congress, to allow Congress to override the court. And we've seen more recently impeach Earl Warren and the rest of it. But I think that what we've seen now is not a flare-up. This is not just a sort of an immediate reaction to a bad decision like Dobbs. This is a sort of a general collapse of faith in the institution, which has earned it. They've come by it honestly. They have not acted like a court. And they are very manifestly, profoundly at odds with the 21st century. I mean, they have, as Charles Evans Hughes put it, back in the 1930s, they have shut their eyes to the plainest facts of our national life, and people get that, and they watch the behavior of the justices, and they no longer trust the institution to do what is consistent with either the Constitution or common sense.
All right, let's talk about Trump. There's a
Oh,
lot
left.
of a lot of cases before the court right now, or have been recently decided in the last, 48 hours, that could have an impact on the election. So most notably and recently, the Colorado ballot case and the Trump immunity question. So what's your take on these cases and how the court is approaching its responsibility that it has taken on and how it will impact November?
Well, I mean, I'll tell you what my take had been on these cases. My take had been that the court was going to do as little as possible to disrupt Trump's pathway to November. I don't mean to the White House necessarily, but his pathway to November as
Mhm.
possible, and that they were going to try to do as little harm as possible along the way. I think I was right about the first part. My dog clearly agrees. Forgive me. Um, or maybe he disagrees. In any event, I think I was right about the first part. The second part, I think I overestimated. I mean, I hate to sort of feel so naive at this point, having watched this court as we all have. I overestimated the majority's capacity for self-restraint. I mean, as both the liberals' concurrence in the Colorado case, the insurrection 14th Amendment case, where they had tried in Colorado to remove Trump from the ballot, as both the liberals and Justice Barrett in her separate concurrence agreed, the 5-member majority went a lot farther than it needed to. And it devised, almost in a parody of what it said that liberal justices used to do. It devised, a new test, a new rule that essentially says the insurrection, for practical purposes, that the insurrection clause is all but unenforceable. That Congress has got to come in and do it. Now, there's absolutely nothing in the Constitution to indicate that. There's nothing sort of around it in the 14th Amendment to suggest that that would be the approach. But that now 5 members of the Supreme Court have said is the way that it's going to go or not go. In other words, so on the immunity case, I guess for what it's worth, I'm hardly alone in saying I find it hard to believe that this majority, even this majority, is going to endorse Trump's claims. I mean, the sort of constitutional equivalent of that statement of his that he could shoot somebody dead in the middle of Fifth Avenue and people would still vote for him. I mean, this is sort of the constitutional equivalent where he's saying, or his lawyers are saying, that if a president ordered a political opponent to be shot dead in the middle of Fifth Avenue, that he would be immune from criminal prosecution. So this is the argument that they are out there making. It's hard for me to imagine that they're going to get a categorical endorsement of that one. That said, the court doesn't need to go that far. In fact, they've already, just by the timing of the thing, as I'm sure everybody has observed, they've effectively taken the government's case against Trump virtually outside the realm of where it can influence the election. And so again, it does seem, even by hearing the case, when it's hearing the case, to be clearing the path for Trump to run sort of unobstructed in November.
All right, so Trump cases aside, I read recently that the court is way, way behind on issuing decisions. That, you ordinarily at this point in the year, they've issued many, many more than they have to date this year. So why do you think that's happening, and are they going to catch up?
Well, again, I should add the disclaimer again that I am neither a clerk nor have ever been a clerk, and I have no particular insight into the inner workings of the Supreme Court. That said, we know that the court can move quickly when it wants to, and it actually did move pretty quickly on the Colorado case.
Right.
Um, and we also know that the court has been moving so quickly that it's been in for a lot of criticism, including from some of its own members, again, citing Justice Kagan, the phenomenon of the shadow docket, where they just kind of move these things down the line and they issue rulings without any reasoning. So again, if the court wants to move, the court can move. But again, I don't think it's too much to say that there is a larger project underway here. And it has been the project of the right since it was conceived in earnest in the early 1970s. the project is to sort of bring down the edifice of the welfare state and the regulatory state and what we're now calling, I guess, the deep state, and remaking the country. And so, there's work to be done, and they are at it in earnest. And so the end of every term now, even more than ever before, becomes sort of exam week. It all just kind of happens in one big rush, and we get that cascade of decisions one after another, and the nation, the rest of us, are left to spend the summer kind of picking up the pieces and figuring out what rights we have left. And I think that, again, I don't know what the overall numbers are relative to before, but I would say that yes, many of the biggest blockbuster rulings were always reserved for the very end of the term. Those sorts of decisions can take longer to write, naturally enough. And also there's a kind of, let's just sort of drop this thing and get the hell out of town. That's always been the case. But there are more of them stacked up upon each other. And why is that? Again, because consequential rulings invite more consequential challenges. I mean, Dobbs begets the challenge that we now have and that they're going to have to address to abortion pills, or the challenges that are happening, kind of at the state level, what we saw in Alabama with regard to IVF. And so, when the court opens the doors, stuff comes through the doors. The Bruin decision, the New York State gun decision last term, I think it was last term. That gets us this term's blockbuster case about whether people under a domestic violence restraining order ought to be allowed to have a gun. I mean, this is now a reasonable question. Why? Because of that preceding ruling. And so, you open these doors, and people are going to sort of rush in to exploit the ruling to just continue to see how much farther this court is willing to go. So that's the exercise that we're in right now. It's, as Justice Breyer said, it's not often that so few have so quickly changed so much. That was back in 2007, by the way. So, yeah.
Okay, so we did a session, as I mentioned at the top of the call, last year about affirmative action and university admissions cases. And we're definitely seeing a lot more cases that are trying to curb affirmative action, DEI, et cetera, extending, past universities to military academies and, sort of getting closer and closer to the private sector. So where do you think this is going to stop? And are we going to get to a point where private companies are going to be forced to unravel their DEI and ESG programs?
Well, where it's going to stop, I don't mean to be sort of just, now for 30 minutes, undertaking a sort of less melodic version of the REM song. I don't know where it stops. It doesn't stop until they are satisfied. And that's a very open question. You asked about what companies are going to do in the wake of the affirmative action decision. They're already doing it. I mean, look at the companies, the sort of honor roll of companies that have rolled back or killed their DEI programs. I mean, this is a partial list: Zoom, Meta, DoorDash, Home Depot, Tesla. Now, a couple of those aren't great players to begin with, but you're seeing more and more of this, and I don't want to sort of put all the responsibility on the Supreme Court. A lot of this retrenchment surely is due to the fact that there's been this right-wing campaign of pushback attacking any company that has a DEI program. You have the fact that not all these CEOs, not all of whom are Democrats, were all that bought in the first place, no matter what they were posting on LinkedIn. But of course, the Supreme Court has an influence here. I mean, West Wing writers, we've got private sector clients, and I'm not telling tales out of school to say I know that those clients were very closely watching the Supreme Court's decision in the affirmative action case, and it wasn't because they have a particular interest in higher ed. They recognize that there will be further challenges, maybe aimed at them, and so the ripple effects do continue.
All right, let's talk about ethics and conflicts of interest. So why is the court going so easy on Thomas and Alito? And there are many compromises on acceptances of gifts and other conflicts of interest. How do you think the other justices, and I know this is conjecture, how are the other justices privately reacting to Thomas, for example, refusal to recuse from cases where he does have a conflict of interest and disclose, some of the more basic kind of financial ties that he has, and that he hasn't historically been forthcoming about.
Yeah, well, I don't know how the justices are responding privately, but I think interestingly, at least a couple of them, um, more than a couple of them have been on the record publicly. I mean, it was interesting to see, I think it was last summer, just before the term began, or the early fall, that not only did Justice Kagan come out a couple of times and say, yeah, we should probably have an ethics code, but actually Justice Barrett said the same thing. And you got the sense that they were speaking not to us so much as to one another, and reminding their fellow justices that there's a problem here. And even if it's not in everyone's view an ethical problem, I don't think that Justice Thomas thinks that there's an ethical problem to speak of here. But there is certainly a PR problem. And I think that they were gently appealing to the kind of self-interest of the justices to do something about it. So they did something about it in the sense that they issued this code. But that too, I think, is mainly PR. I mean, it's pretty toothless. I think that, when you look at what's been at issue, and let's not pick only on Justice Thomas here and his RV and the free education that was given to his family member and the Lincoln memorabilia, and there's a long list of this sort of stuff. The flights on corporate jets and the luxury yachts, and it's like a pretty good gig for a public servant, right? And all they're being asked to do is list it, file it, mention that they're doing it, and he can't even bring himself to do that. Um, and all manner of free stuff from corporate benefactors who obviously have no ulterior motive, and it's offensive, Gayle, that you would even suggest that they might have one. Especially when, as Justice Alito wrote in the Wall Street Journal in responding to all this, that, quote, no reasonable and unbiased person would think that anything was at issue when a billionaire took him on a fishing trip. He made a point in this piece, if any of you read it, and I encourage you to read it because it's the least self-aware piece of writing that you will encounter. That it was actually pretty rustic, he says. Rustic is the word that he made a point of using. And the wine, he said, everybody's talking about the wine, but it definitely costs less than $1,000, he said. So I don't know if any of you have had a bottle of wine that costs more than $1,000. You can mention it in the chat, or you can send me a bottle. But they are a little bit sort of out of touch with what reasonable and unbiased people actually might think. But this is, again, the problem with the code, is that the code simply says we care about this stuff, and it clarifies exactly the arrangement that preceded the code, which is that Justice Alito will tell you if Justice Alito has an ethics problem. And Justice Alito is on record as saying that Justice Alito doesn't. So this is the end of the discussion. So I'm not sure that we've gained a whole lot, not even a tremendous amount of face saving on the part of the justices.
You think that an effective way of dealing with this is what John Oliver is doing, suggesting that he will offer Clarence Thomas $1 million plus a $2.4 million RV to step down? Should, should we
I,
give
th-
that
I
one
think it's
a
got
try?
to up the ante, really. I mean, if there's a going rate, it's more than $1 million. What do you think?
Got it. Okay, so last question before we open this up to our classmates, and still staying on this ethics question. Do you think, given Thomas's wife and her efforts, her involvement in efforts to overthrow the election, should he have recused himself from the Colorado case? Um, would that have been an appropriate move for him?
Yes, well, sure. Absolutely. I mean, I think as a reasonable and unbiased person, I'm going to say yes, he should have recused himself. Um, I actually I was able to attend that oral argument. And I have to say the feeling of cognitive dissonance of sitting there listening to them. They weren't debating, again, as I think everybody knows, they didn't actually debate whether or not Trump was an insurrectionist. But that was the context for the entire conversation. And I was watching Justice Thomas and thinking that, it is his wife, the activist Ginny Thomas, who was throughout that period and on January 6th texting Mark Meadows at the White House and offering her sort of her blessings and good wishes and ideas. And it's Ginny Thomas who sort of invoked "Stop the Steal" as kind of a holy cause. So of course he should have recused himself. But again, the rules of recusal are that Justice Thomas will tell you if he thinks Justice Thomas needs to recuse himself, and the answer is always going to be no. And so we're in we're stuck when it comes to cases like that. Um, I feel like I've just been absolutely delightful tonight, just full of good news and
Well, good cheer.
positive ideas and
Yeah, can you leave us with
solutions.
like
And
some kernel of hope of any sort about our democracy and the future health of this world?
a kernel of hope is that we still have the vote in November. And another kernel of hope is that I think um, I actually think that um, I'm going to take heart. I'm going to choose to take heart in the 2/3 support for the idea of term limits for justices. I do think that, again, as I said before, that this is not just sort of you know a period of bad press for the court, but that the country is actually term after term now, and really month after month, having to reckon with some fundamental questions about judicial power. And we're in the worst of it right now. And it's an open question whether sometimes when I've talked to reporters about this and they say, is this 1937? Are we on which is the year that Roosevelt proposed to pack the court, and the whole thing sort of came to a head. And my answer is always no, it's not 1937. And I think the question for us really is it the 1930s at all, or is it the 1890s? I mean, are we at the beginning of this period of time, or are we well into it right now? We don't actually know. But I think wherever we are in that trajectory, I think that there is a sort of growing sense in the country that something is deeply wrong here with the way that judicial power is being exercised in this country. And so I think it is going to take some time to work itself out, not merely in the sense that, somebody will eventually retire and then somebody else and somebody else. But I think that there is a rethinking that needs to be done and might be in the process of beginning. Maybe that's not as hopeful as all of that, but I do think it's encouraging that the American people don't actually look at this and think, this is fine. This is actually what judges are supposed to do. I think most people agree with Justice Kagan that the court is not acting like a court. And so when you establish that, then the big question, again, was your question, Gayle, what are we going to do about it? And a very open question right now, but it's being asked.
Okay, great. So if you have a question for Jeff, and it does not have to be about the Supreme Court, it can be about any of the books he's written, about writing speeches, working in the White House, Thatch, anything, please feel free to ask. So I think we have a question. Brendan. Okay, Jeff, what was your favorite memory of working in the White House? And what was your most difficult memory of working in the White House?
I'll start with the latter. The most difficult speeches to work on, which led to some of the most difficult moments for me, were the comedy speeches, which I loved. And some of my favorite memories are associated with seeing the comedy speeches delivered. And I mean the gridiron, the White House Correspondents' Dinner, the comedy shtick that presidents do. President Clinton was really quite willing to have us kind of push the boundaries of what a president would do in a speech like that. We got to sort of write these videos that he was willing to act in. I mean, an enormous amount of fun. But there was something about those speeches that internally in the White House, people would fight tooth and nail over jokes, over getting their jokes in, or killing jokes that they didn't write or that they didn't like. The only shouting match that I remember with a senior White House staffer, where we both actually ended by slamming the phones down, and that when you actually could slam the phone down and not shatter your screen, was over the White House Correspondents' Dinner speech. And then the battle for credit afterwards was fiercer with regard to those speeches than nobody was that interested in taking credit for the State of the Union. But those speeches, boy, people went on a media tour to establish they had written all these jokes. So we actually, at one point in 1998, um, somebody sort of showing off to a reporter leaked one of our best jokes to the reporter. And so the joke actually ran in Politico or wherever it was before the speech had been delivered. So that killed the joke. So these were weirdly contentious, and fun at the same time. Gosh, what was my favorite memory? I think that there are so many. It's hard in the moment to kind of process them, the sense of unreality that kind of hangs over it. You're not supposed to admit it. Everybody's sort of too cool for school, like everybody's an old hand. But privately, you're taking a couple steps back and enjoying what it is that you're seeing. I think one of my favorite memories was actually the very first speech that I wrote. Um, uh, Early in 1998, I was given a really important speech to write, which was about food safety, and steps that we were taking to protect against salmonella infections. And It was a 4 or 5 minute speech in the Roosevelt Room. And it was not the kind of speech that President Clinton would spend a lot of time working on. And So he delivered it in the Roosevelt Room as I stood in the back of the room. He delivered it word for word, which was very rarely the case, as I was about to find out. When you have a president who's a great extemporaneous speaker, he's not going to always stick to the script. Um, and I was in the back of the room, kind of having this out of body experience. That this sort of poetic line that I wrote about vegetables was being uttered by the President of the United States. And when it was over, my boss, the chief speechwriter, sort of slapped me on the shoulder and he said, "Well, that is as close as you will ever get to being President of the United States." Um, which captured a lot of it, and continues to be true to this day. It is as close as I ever got.
Okay, we got a question here from Daniel Moss. Jeff, thank you. Any thoughts on how the perceived illegitimacy of the court, the fact that I believe at least 5 justices have been confirmed by presidents who lost the popular vote, in addition to the stolen Obama seat, of course, and the exceptionally expedited Barrett confirmation process, contributes to the lack of trust in it as an institution, and what, if anything, can be done about it?
First, hi, Dan. Good to see you. And I completely agree with the premise of your point, and I should have mentioned it in my long bill of particulars there. Absolutely, I think the sense of the court as being manipulated and being manipulable to that degree, the idea that games like that could be played with such high stakes, and that positions like this, which used to be regarded as kind of above politics and kind of in a civic sense kind of sacred, that you would have a succession of people stuffed by various means into these roles, each one of them suspect. And as you pointed out, I mean, the first by holding that seat that should have been Garland's open for the better part of a year. That's Gorsuch. The second by sort of stuffing somebody who had been very credibly accused of sexual assault into the seat. And the third, after, like, in the midst of a contested election at the last possible minute. And so I think that I definitely, I mean, I've been now sort of talking to folks formally and informally about the court and court packing since that book came out almost 15 years ago now. And I will say that the change in temperature was dramatic. Once, I mean, really after the first of those offenses, but then you have a run of 3 of them in a row. And I think that, okay, so that's sort of the sort of beltway crowd, I guess. There's no getting around the fact that Gayle and I live where we do. Gayle, I'm sorry, I don't mean to drag you down with me, but
Okay.
but I think that for the country as a whole that watches this kind of political spectacle about the way a Supreme Court seat gets held open and the way that it gets filled and who fills it, I think that I think it certainly has some effect. Uh, I think that it corrodes what remains of the court's legitimacy and casts a kind of pall over the decisions that follow it. I mean, it really makes very clear that the court is just another instrument, as I said before, as others have said, of politics by other means. Absolutely, I think those are big elements in this.
Okay, here's another question from you from Lisa Bimani. Jeff, there's a lot of talk about a new space race about our adversaries knocking our satellites out of orbit with nuclear weapons. Do you have thoughts about this given your book, Mercury Rising?
Hi, Lisa. Thanks for coming and thanks for the question. I do think that, I mean, it's interesting. We're not a space race in the traditional sense. It was very easy to see what was happening or said to be happening in the early 1960s. There were two big players, and one would do something, and then the other would do it, and it just the sort of the one-upsmanship until one essentially the Soviets obviously sort of fell back and fell out of the race, and it wasn't some kind of extraterrestrial Olympics where everybody was just kind of competing for national national pride. It was seen to be an existential contest in which, as Lyndon Johnson and John Kennedy both said, whoever controls the heavens will control life here on Earth. There was the sense that if the Soviets won, meaning if they established their dominance and held their dominance in space, that we would be living under a perpetual kind of umbrella of nuclear blackmail, if that now sounds familiar. So it was exceedingly high stakes, as it was understood by people, not just in these two countries, but around the world. It's blurrier now. There are more actors involved. You know, Administrator Bill Nelson at NASA and others have talked about the contest between the United States and China. Nelson has said, what China is doing in space ought to provoke us to, as he put it, in his way, get off our duffs and be more competitive in space. But I think one of the reasons that hasn't really sort of taken hold as a kind of construct that gets people freaked out, worried, energized, whatever it's supposed to do, all of these things, is because it just doesn't cut as neatly as that. You've got the Russians doing what, and I think this is probably the basis of your question, Lisa, the Russians, testing more and more of these anti-satellite weapons and potentially nuclear weapons in space. You've got other players in space as well. You've got, India, UAE, Israel, other nations landing or trying to land things on the moon. And then you've got all these private companies as well, some of which are acting in concert with NASA and some of which just aren't. And so it is a big, messy, blurry picture. And so is there a race? There is absolutely a race in the sense that everybody's trying to get up there. Everybody's trying to sort of fill low Earth orbit with their satellites. Everybody's trying to get to the moon. Everybody's trying to get close to the source of water and the south pole of the moon and figure out what we can do with that, if we can extract it and all the rest of it. So there is definitely a kind of a race mentality, but it isn't the kind of one-on-one playing for all the stakes kind of contest that we had that was so clarifying in the 1960s.
Okay, so we have a couple more questions that we'll try to squeeze them in here before we close at 9. One of them comes from Sarah Showett's husband, John Mikhail, who is probably rivals you for knowledge of the Supreme Court. John asks, from your perspective as someone who studied the 1930s Supreme Court and its quote unquote settlement over the New Deal, how do you regard the new wave of conservative attacks on the administrative state? Do you expect that the current court will unwind aspects of the New Deal settlement? If so, how far do you think it'll go?
Really great question. I mean, it's about to go a lot farther. I think the ruling in the Chevron related case this term is preordained. I think we know that they're going to take a huge leap in the direction of deregulation this term. And how much farther will they go? I mean, how much time do they have? I mean, I think that's really that's the question. I don't think there's necessarily a natural limit to the contempt there is for regulation. I mean, all of this started. I mean, when you look at the career of Justice, the late Justice Scalia, I mean, he began as a deregulator. This was the obsession. And so this is part of one of the big projects of this sort of larger project that we're talking about. And I think that it also is revealing, with regard, as you said, to the New Deal, in that this is running the New Deal playbook in reverse. I mean, they used to talk, they've since sort of retired the phrase, but they used to talk 10, 15 years ago about what they call the Constitution in exile. And the idea was that in 1937, when the switch in time that saved nine, the court flipped amid this threat from Roosevelt, and never went back for generations. That the Constitution has been in exile ever since 1937, and they want to bring it back. And by bring it back, what they mean is they want to again sort of turn the clock back, pre-New Deal and pre-sort of New Deal era understandings of the Constitution and what the Constitution has to say about the scope of federal power and regulatory power and all of it. They have found that it is extremely difficult to do this, or impossible, in the Congress or at the ballot box. It is really unpopular to unwind these programs, which is why ultimately these challenges, I mean, look at the Obamacare battle, you know, repeal, repeal, repeal. They can't repeal it. It goes to the Supreme Court, and it survives just barely the test there. But the goal is to get the court to undo what the Congress can't undo, because Congress has got to get itself reelected. And so this is part of that larger playbook. And they're about to have, the biggest success that they've had in that regard. Here I go again toward the end of the hour. I'm, sounding dire again, but this is a good reason to be concerned about this court.
Okay, so this will be our last question. And before I ask, I just want to thank everybody for joining us tonight on behalf of your class officers. We're always thrilled to see how much engagement and activity we get from this class. It's a fantastic class, and we will continue working on providing programming and events and things to keep us all engaged as we are in the kind of midpoint before our next reunion. All right, so our last question here comes from Lawrence Stern. And the question is, has there ever been a serious discussion of proposing or passing a law that would have an age cutoff, both for the president and for the Supreme Court justices? So some sort of a mandatory retirement age, as we're dealing with lots of unhappiness about the age of our presumptive nominees. I guess I won't even say presumptive after yesterday, age of our nominees. Anything that any thought on that?
Yes, with regard to the president, I don't know about that. I'm not aware of it, which isn't to say that that it hasn't happened, that it hasn't been proposed. With regard to the court, absolutely yes. I mean, this was a fixation in the 1930s, that the way to solve the problem. Again, I mentioned that that it was the oldest court in American history to that point. They were known, popularly as the Nine Old Men, because they were. The youngest was 60, and he was a lot younger than most of the rest of them. And so Roosevelt, among others, explored the idea of imposing an age limit on the justices. And it was actually a reasonably popular idea, although it was often pointed out that the oldest justice was Brandeis, and he was, the great sort of liberal champion. And so it didn't neatly cut in the direction that it was set at the time. But that needed and needs today, if it were to happen, it requires a constitutional amendment, almost certainly. And Roosevelt decided against a constitutional amendment of any kind, whether it had to do with age limits, term limits, or anything else. And so I'll just be brief because we're almost out of time here. The court packing plan itself, for those of you who aren't familiar with the details, actually was attached to age. It wasn't simply that he said, we've got a court of 9, let's have a court of 15. He wanted to hang it on a kind of a device. And so what he contended was that what he proposed was that for any justice 70 or older who refused to leave the court, refused to retire, since you couldn't force them off the court, that he would get to appoint a new justice to essentially sit beside the old justice and work more efficiently. The idea was that these guys were too old to do their work on time, which wasn't actually true. And so there were 6 of them who were 70 or older. So that would have allowed Roosevelt to appoint 6 new justices, assuming none of them left. That's how you get to 15. And then suddenly everybody sort of said, that's so ungenerous and mean to old people. They didn't like the sound of it when it had actually been proposed. And so it was one of many knocks against court packing plans. So yes, the answer is that that has been an idea that has been, and that wasn't the first time that anybody had proposed anything like that. But as I'm closing, before I do, Gayle, I just want to thank you so much for inviting me to do this and for joining me in this and for all your questions. And this is just such a pleasure to talk with you and again to see so many of our friends turning out on a weeknight and asking these questions. And I'm really grateful to all of you. This is a lot of fun for me.
Well, I had the easy job. So, Jeff, thank you for sharing your wisdom. And we look forward to, oh, what is your next book, by the way? Do you have something in the works?
This is when I click leave out of the meeting. Um, I wish I had an answer for you. I'm thinking, but I haven't figured it out yet. But
Okay.
thank you for asking.
I think there's still a career in cartooning for you if you decide to go that way.
Maybe so. I'm not sure there ever was, but maybe next time.
All right. Thank you, everyone. Have a great night.